So hello, everybody. We are nearing the end of yet another successful Tilting conference. It has been a busy 3 days, and I would like to take this opportunity to say thank you to our indefatigable organizers and the Spectrum team. The theme of this conference is regulating in times of crisis, and that is exactly what they have been doing behind the scenes, regulating and diffusing all the technical crises that tend to spring up when hosting a virtual conference with over 600 participants coming from all over the world. So kudos to them. A very special thank you also goes out to all the presenters, panelists, moderators, and of course to the members of our audience for your wonderful contributions, each and every one of which helped to make this conference a success. This is our first attempt at hosting the Tilting conference in a virtual format, and your participation and enthusiasm has been a source of great encouragement. So let's move on to the final item on the conference agenda, which is the keynote address for the intellectual property law track. We are honored to welcome Professor Mark Lemley as our keynote speaker. Professor Mark Lemley is a renowned international scholar, commentator, and if I may say so, innovator in intellectual property law. He is the William H. Newcomb Professor of Law at Stanford Law School, a senior fellow at the Stanford Institute for Economic Policy Research, and the director of the Stanford Program in Law, Science, and Technology. At Stanford, he teaches intellectual property law, the law of antitrust, the law of robotics and artificial intelligence, and interestingly, video game law. In addition to his academic commitments, he is also active as a legal practitioner in the area of IP law, internet law, and antitrust, and is a founding partner of Dari Tanri LLP. Professor Lemley holds the distinction of being the most cited scholar in IP law and is one of the 4 most cited legal scholars of all time. He is the author of 8 books and 185 articles, and his works have been cited nearly 300 times by courts, including 15 times by the United States Supreme Court, and more than 18,000 times in books and law reviews. His articles have also been translated into Chinese, Japanese, Korean, Spanish, Italian, and Danish. So his influence as an IP law expert, both at the levels of policymaking and litigation, is unparalleled. It therefore comes as no surprise that he has been recognized by the American Lawyer magazine as one of the 25 most influential people in IP law and inducted to the IP Hall of Fame in 2014. In 2018, his work in law and innovation was also recognized and distinguished by the World Technology Award for Law. Professor Lemley's keynote address today is entitled The Contradictions of Platform Regulation, a hot topic in contemporary IP law, especially here in the EU since the enactment of the infamous Article 17 of the Copyright in the Digital Single Market Directive. So we are very happy to have you here, Professor Lemley. Thank you so much for accepting our invitation. And without further ado, the floor is yours.
Thank you. Thank you very much for that kind introduction. I am going to I put a link in the paper and I'm going to talk a little bit about some of the sort of contradictions of platform regulation. So everybody wants to regulate tech platforms. Seems to be we don't agree on a lot of things in the world, but everybody seems to agree across political lines, across national boundaries on regulating technology companies. What I suggest in the paper is that they want to do it in radically different and in fact inconsistent ways. The consensus that you see at some level for regulation is illusory. Or at the very least, that it conceals a number of fundamental contradictions and oppositions that we're going to have to deal with as we think about how to regulate tech companies. So let me start with a number of proposals to regulate tech companies that strike me as sort of flatly contradictory. The first is what we do in the United States about Section 230 of the Communications Decency Act. For those of you who aren't aware of it, Section 230 immunizes platforms from tort liability for content posted by another. So it's the reason why a company is not liable if a poster on the site defames another person, for instance. But it extends to any form of tort liability. It does not extend to criminal liability or to intellectual property infringement, but is otherwise a pretty broad form of immunity. Everyone has taken shots at Section 230 in the last few years on both sides of the political aisle. There seems to be a consensus that we need to sort of get rid of or at least weaken this immunity for tech platforms. But when you look at why it is that they're doing that, you see something fundamentally different in the approaches. So the Democrats in the United States want to weaken or eliminate Section 230 in order to force platforms to be more active in policing content. They want to force platforms to take down hate speech, to take down disinformation, maybe to take down Donald Trump. And the fear on the Democratic side is Section 230 gives you immunity from liability if there's bad speech on your platform, and therefore you don't have sufficient incentive to remove bad speech from your platform. The Republicans in the United States, by contrast, want to change Section 230, but their objection is exactly the opposite. Their objection is that platforms are too aggressive in taking down content. They have the freedom to do so. And the Republicans want to require platforms to allow any content in the United States that is constitutionally permissible. And in the United States, the constitutional reach and protection of free speech is quite broad. So that means, I think, more hate speech and misinformation than exists on the platforms now. Probably also means, frankly, a lot more pornography than we see on the platforms right now. So while we've got an agreement that we should do something about Section 230, we should have greater control over what platforms do with content moderation, that agreement masks the fact that what the parties actually want people to do with content moderation is exactly the opposite. Republicans want less of it, Democrats want more of it. And that's going to make it, I think, very difficult to sort of create a rule on Section 230 on which everybody can agree. Ironically, when it comes to net neutrality, the positions of the parties are reversed, right? Where the Democrats tend to support a neutral platform at a lower content layer, and the Republicans oppose the idea of net neutrality, right? So if you're a Republican, you think the platform should be required to pass all content along, but that the cable provider should be able to discriminate on the basis of what content is permitted. Democrats seem to believe the opposite. Second form of sort of contradictory, or at least sort of regulatory proposals that are in tension with each other, has to do with antitrust and advertising. So we've got a number of objections and problems that sort of show up in this version of antitrust. One of those objections takes the form: platforms monopolize the advertising market. They take over that market. They charge higher prices to advertisers. A second objection is platforms collect and share too much data about us. And a third objection is platforms are diverting ad revenue away from worthy sources like newspapers and taking and bleeding dry the advertising market for newspapers. And one or more of these things might be true, but what I want to suggest here is that they those claims exist in considerable tension with each other, particularly when we think about what we might do about it. So if Google and Facebook, in fact, dominate the ad placement market, they have the power to charge advertisers higher prices. But if they're charging advertisers higher prices, the newspapers that want to compete with those platforms and consumers who would like less targeted advertising should be happier about that, right? They're getting less of the thing they object to. And antitrust intervention aimed at sort of having a more competitive digital advertising market, I think would mean more advertisers using more of our data for less money and more competition, and therefore less revenue for the news organizations that can shelter under that umbrella. Now, none of this means, I think, that there isn't a real antitrust problem in digital advertising, right? So to give two possible examples, right? If, as alleged in the United States, Facebook and Google are colluding in their digital advertising markets, that's a problem we need to solve. If Google is manipulating auction results to sort of disadvantage competitors, that's a problem that needs to be solved. Nor do I want to suggest that there isn't a broader antitrust problem in tech. In fact, I'm going to talk about some of the ways I think there is. We just came from a panel in which I talked about some possible solutions. But a number of the things that people claim to want from antitrust intervention in the advertising market in the digital space, I think are at odds with each other. Right? If what I want is fewer advertisers targeting their ads and having access to my data, antitrust is the opposite of the thing you want to get. That same problem, I think, is even more clear when it comes to the proposal to break up data monopolies. So there's a lot of worry that there's just too much data concentrated in the hands of one or a few companies, and we need to break up those data monopolies because they have too much concentrated power and information about us. But I think that worry, which is a real worry, exists in considerable tension with the worry that in general, there's too much data about us floating around out there. If we break up data monopolies, right, each individual company might have less control over the data about us, but more companies will have access to our data and we will have less privacy associated with that data. Conversely, if we take the privacy approach and we say we want to restrict the flow of information, we can restrict the flow of information and give fewer companies access to our data, but doing so is going to entrench those who already have the data. That is the big data monopolies. So we've got a contradictory set of impulses that says, make this market more competitive, break up the data monopolies, but on the other hand, let fewer people have access to our information. And those, the proposals to do those things push in opposite directions. Finally, we also see a sort of contradiction in proposals around cybersecurity. Governments very much want to stop data breaches and hacks. They'd like to stop third parties from getting access to corporate information, getting access to our information by breached passwords and the like. But those very same governments also want to ensure that they have their own backdoors into people's accounts and devices. And governments across the sort of world, from democratic to authoritarian, have been insisting on building in backdoors to make sure that the government itself can access the data that it wants hackers not to be able to access. Similarly, governments are taking efforts to try to ban end-to-end encryption for some combination of political or law enforcement purposes. And doing those things is going to make cybersecurity much harder. Right? You can have a secure private system if you build in real full end-to-end encryption, but if you do that, the government's not going to have access to the information that it wants. If you give government access to the information it wants, you're going to do it both by weakening the cybersecurity and by collecting in the hands of a government all of the data that we're concerned about people having access to, making that an easy and obvious target for hackers. We've also got a couple of circumstances in which the laws sort of already require, if not inconsistent things, at least sort of things that push in different directions. So the EU has laws that require that you keep data as a tech platform, and also that you not keep data as a tech platform. Right? We're concerned about sort of private information sitting for too long. So there's a regulation that says you can't keep this information for more than 24 months. The easiest way to comply with that regulation would be not to keep that information at all. But the EU also said, oh, but wait a minute, we may need that information. So there's also a requirement that you keep that information for at least 6 months. This isn't a direct contradiction, but we've got a window that you can comply. But it is a result of sort of opposing pressures coming from the same source in the EU. Another example, I think, of those opposing pressures involves geo-blocking. Europe has effectively required American companies to engage in geo-blocking to ensure that content that is lawful in the United States but illegal in Europe, like Nazi memorabilia, can't be accessed from European sites. And I think you can read the Schrems decision as a sort of massive form of geo-blocking, essentially saying people who have data on European citizens must ensure that that data doesn't end up going to the United States because the privacy shield, the data shield is ineffective, and we can't guarantee that the US will provide effective privacy protection. All of that pushes very strongly towards a kind of nationalized or at least regionalized access to information where what you see on the internet depends on where you are. But at the very same time, the EU also banned private efforts to engage in geo-blocking in Europe in the copyright context because it was worried about concerns about price discrimination. That decision is in some doubt after the court's decision in Groupe Canal. But here again, I think the EU, not a direct contradiction, there are different rules to which it applies, but the EU is taking inconsistent positions on geo-blocking depending on who is doing it and why. Finally, I'll just say a couple words about some of the sort of regulatory proposals that are maybe not so much contradictory as just plain silly. I confess, and this may or may not be a good audience to make this claim, I confess that I think the newspaper link tax in Europe is one of those just plain silly rules. So the law declares that a search engine linking to a news headline provided voluntarily online by a newspaper to be a form of sort of para-copyright infringement. When it declared it to be a form of para-copyright infringement, Google News said, well, okay, fine, we don't want it, we won't do it anymore, right? We don't want to engage in copyright infringement. The newspapers were aghast. Of course, the thing that they've declared to be copyright infringement is also the thing that drives a large percentage of their revenue. So we changed the law to require Google to engage in the thing that we have just declared to be infringement. And then, of course, to pay damages for having infringed the right. Google says, well, we don't want to do that. But the EU then sought to enforce the requirement that Google violate the new copyright law that it had created by arguing that not infringing copyrights and paying damages for that infringement was an antitrust violation on Google's behalf. So the EU rule, I think, is under Article 15 is now, don't use our stuff without paying, but you must use our stuff. And that strikes me as perhaps serving a kind of an ultimately worthy goal of the form, you have money and we would like it, right? That money would be better in the hands of newspapers, but strikes me that if you want to do that, the right way to do it is to impose a tax in general, not to try to declare something to be copyright infringement, but then mandate it. Even sillier from the United States side, there are a lot of concerns about algorithmic targeting of content. Am I sort of being personalized and having messages sent that sort of reinforce my worldview or are focused on what I know? So Republicans in Congress have introduced bills to require search engines like Google to offer a, quote, algorithm-free experience. You can use an algorithm in providing content, but you must also offer a non-algorithmic alternative that is not targeted. An algorithm, the bill defines as sort of any technology that uses an automated process to decide what you see. Hard to imagine, actually, how you have a search engine that doesn't use an algorithm. In fact, it's hard to imagine how you have pretty much any technology that delivers content that doesn't have an algorithm. Asked to imagine any aspect of the internet that didn't involve an automated process. One expert quipped, "I picture a computer that is turned off," close quote. So, you know, will this become law? Hopefully not, right? But it's part of the sort of instinct that we must regulate and sometimes without thinking through the consequences. So what's going on here? I think for some of these contradictions or inconsistencies, the contradiction should make us question the instinct to regulation altogether. I think that's true, for instance, of the efforts to limit Section 230 of the Communications Decency Act. Right? The fact that we insist that the government have a role in making content moderation decisions, but that we can't agree even on the direction of what that role should take, right? That we're demanding diametrically opposed things, ought to make us question whether it is the case that the government ought to have a role in content moderation decisions, right? And certainly, I think there are plenty of problems with the content moderation systems we've got from private companies right now, but it's not at all obvious that we will be better off in a world in which the government decides what things must be included and what things must be excluded from that content. I think something similar is true of the newspaper link tax, right? The fact that you write a law and then you're very upset that anyone's going to comply with the law because what you wanted was actually something different than what you wrote, right? Ought to make us go back and question, right, whether or not this law is a good idea in the first place. And certainly sort of folks like Australia and Canada, which are now thinking about extending the newspaper link tax that Europe developed, ought to take a good hard look at sort of the logic of it and whether there are alternatives to get what they want, more funding for newspapers, that are less problematic. There are various problems with the newspaper link tax, but even if you sort of accept it on its own terms, one of the things it does is give more funding, not just to sort of news media writ large, but it gives more funding to news media in direct proportion to how many people click on a particular headline link. That fact, right, is going to drive more and more clickbait headlines, right? Already, I think a significant amount of our misinformation problem online comes from the fact that there are significant incentives to put misleading headlines in order to draw clicks. I think we will sort of extend that to the mainstream news media if the way you get paid under this model is by click. You have a strong incentive to write a headline that's going to draw interest, whether or not it actually represents the story. So for some of the contradictions, we ought to be questioning whether we're regulating at all. For others of these contradictions, I think the real problem is just that there are trade-offs. Right, and a lot of the proposals tend to elide or ignore those trade-offs when, in fact, we need to confront them. So examples here, I think, end-to-end encryption, the data retention rules, breaking up data monopolies, all to me fit in this category. Right? There are good arguments on both sides of we should let the government have access to information for law enforcement purposes, and we should have strong encryption to make sure there isn't hacking. There are good arguments on both sides of companies should be required to retain data in case we need it for law enforcement purposes. Companies should be required to delete data so it can't be subject to hacking. There are good arguments on both sides of break up data monopolies and give each company less power, or give fewer people access to our private information. But you're going to have to choose. You're either going to have to compromise, right? Find this sort of middle ground, and as Europe did with the sort of no less than 6 months, but no more than 24 months rule. And in doing so, understand that you're not really going to fully achieve either of your goals, right? Or you're going to have to pick a goal. And you're going to have to understand that in doing so, we have to sacrifice the others. You're going to have to say, right, encryption and data and cybersecurity is more important than the law enforcement having access to this information. Or you're going to have to make the opposite judgment, but we're going to have to make a choice. Stepping back here at the end to a kind of broader view, I want to sort of think about the question of why it is there are so many contradictions in platform regulation. Why are there so many contradictory demands here? And I think part of the reason that there are so many contradictory demands is because of the outsized influence that technology companies have on our lives. Right? These are private companies, but their rules, for all intents and purposes, feel like government mandates. People don't feel like they have a choice if they don't like the rules that a sort of dominant tech platform imposes. They're locked into a phone. They're locked into a social media network. They don't see an alternative, substantial alternative to their search engine, and so forth. And that naturally provokes calls for regulation, right? These companies have a major influence on our lives, right? The law should control what and how they can exercise that influence. But I think we'd be better off, right, not with a dominant tech firm that is subject to regulation, but with a market that was more open to competition. So I think we ought to encourage nascent competitors and stop them from being acquired, swallowed up by the dominant firms, and then often shut down. If you were in the antitrust remedies panel just now, right, I talked in some more detail about that. I think we need to permit what Cory Doctorow calls adversarial interoperability. My ability to sort of interact my software and my technology with yours, even if you don't want me to, even if it competes with you. For instance, allowing a competing social media network that has a different set of privacy values to have its customers have access to their social graph, right, to the information and content that they have on Facebook. Right now, we have an increasing sort of morass of laws that sort of have made interoperability less and less possible in the online world. And we need to sort of change those laws and think about how to sort of structure a kind of truly open internet. But I think in the long run, our choice is one, right, that is between restarting the competitive process that has stalled, right? Trying to sort of bring and introduce competition into a market that has been lacking it for the last decade or so, or by making a series of regulatory choices that are themselves likely to lock those incumbents into place. While the goal is to constrain what the incumbent tech companies do with their power, I think every regulation is also one that cements that power into place. It makes it harder for a startup to appear because they'd have to comply with all of those regulations as well. And it sort of makes us kind of settle into a world in which Google, Facebook, Apple, Amazon are here to stay, and they're the only choices we have. And I think that's ultimately a world we shouldn't accept. So with that, I will stop, and I'm happy to take questions.
Thank you very much, Professor Lemley. That was a very enlightening talk. So if you have a question, you can just ask it directly by unmuting yourself, or else please type it in the Zoom chat, and then I can direct it to Professor Lemley. Any questions? Well, till the audience members come up with their questions, I actually have a question because you started the theme of your address was contradictions. And I was wondering whether the kind of regulatory framework that is being adopted now on both sides of the Atlantic is also quite contradictory, because in order to regulate platforms, they're also giving platforms greater power, let's say, in how those regulatory frameworks are being designed, because now what is being favored is more a self-regulatory approach where you put pressure on the platform and then sort of incentivize them to come up with their own structures. So for instance, the Facebook Oversight Board. So by trying to make sure that the right holders' interests are protected, for instance, in copyright law, and then putting pressure on these platforms, but then not really having a centralized regulatory framework, is there a contradiction there where you're trying to take control away by the platform, but at the same time give them more control? I would just like to know your take on that.
Yeah, that's an interesting problem. I mean, I think I do think there is a sort of there is a sense that, right, those forms of kind of, I don't know, self-regulation, or at least sort of kind of co-governance, participatory regulation are less intrusive, right? And I think that's right at some level, right? We some of the dumber regulations we have had throughout history, right, come from a government that sort of hasn't really understood the the framework it's regulating, and so it imposes something that just doesn't make sense. And I would put we'll just have an algorithm-free Google in that category, right? So you avoid that if you sort of involve the company in the regulation. But I think involving the company in the regulation has its own set of issues and concerns, right? One is, I think that you have a capture problem, right? In privacy in the United States, for instance, self-regulation has long meant we'll do the minimum we can do to avoid having a statute imposed on us, but we won't actually really do much about privacy. But it also means, I think, that companies might set the agenda in a way that affects the ability of others to participate. So Google's Content ID system ends up sort of kind of bypassing or going around the DMCA takedown system for copyright, for instance. But it's also something that took $200 million to develop, that requires continuous management and tweaking. And so if we say, well, that's the norm, and so anybody who wants to develop a video sharing site, you better do something like Content ID. Well, you've made it sort of possible for big companies that can invest a lot of money to do it, but you've made it much harder for everyone else. And I think I think the sort of recent article passed in Europe may have a similar problem. There is an effort to sort of kind of exempt sort of very small companies, but you don't have to be very large before you're subject to a requirement to essentially make sure there's no copyright infringement on your site, and that's a tough requirement to deal with.
Thank you. I think Juan has a question. Go ahead, Juan.
Well, thank you very much, Sunil, and thank you, Professor Demli, for your presentation. I think the question about why there are so many contradictory efforts to regulate big tech is a very important question, and you already gave us your take about the outsized role of big tech in our lives. But I was wondering whether it reflects the clash of values. I teach policy analysis, and in policy analysis, one is designing policies, and you can only formulate one type of solution. It probably means that there's only one criteria or value that you're following. It could be efficiency, it could be equity, you name it. And normally when you take into account different values, different objectives, well, you can come up with a menu of alternatives, and then of course you evaluate and you recommend. But isn't there a clash of fundamental clash of values that we can see in other domains? So, for example, in the US, nowadays we're seeing some states trying to curtail voting rights, and then there's other states trying to do exactly the opposite. And of course, there's racial tensions behind that. So I was wondering if you could develop a bit more about that question of why are there so many contradictory efforts? Thank you.
Yeah, and Bart actually has I think a kind of interesting tweak on this question in the chat, right? So, right, are we speaking sort of from fundamentally different values, and if so, what can we do about it? I mean, I think to some extent the answer is, so I think the answer is yes, at least in certain cases we are. Sometimes those values reflect, in fact, I think, sort of common commitment to a social end, but disagreement about how to get there, right? Or how we value different amounts in the trade-off, right? How big a worry are private computer hackers versus government access to our information, for instance, right? And I think there you can find compromise, right? You can find sort of solutions that aren't going to satisfy everyone, but are going to maybe sort of balance the competing interests based on how we feel about them. But I also think there are more fundamental differences, and those are harder to deal with, right? So you give the example of voting rights. I mean, great. If you think the problem is that too many people vote, and you want to stop that, right? You are not going to come to compromise with people who think the problem is that too few people vote and we need more, right? Your interests are divergent. And I think we see that on the internet primarily in kind of different national examples. So, Bart's example talks about sort of the US and the EU. We do have differences in the US and the EU, but I think they pale in comparison to the differences in approach to that other countries bring, right? So I think China has a fundamentally different set of values when it comes to what it wants and doesn't want on the internet that may just be incommensurable with the things that we're interested in, both in the EU and the United States. That might be true of Russia as well. And I think that becomes a really hard problem because one of the real benefits of the internet is precisely that it transcends national borders, right? And so the more we splinter it into competing national domains, the more we may allow each of those countries to implement its values, but the sort of more we lose of the thing that makes the internet great, right? Which is the ability to actually have some arbitrage and kind of shared experiences of those different values. So I think it's real. I think it's a real problem, and I think for at least some of these cases, it may be an unsolvable problem. But I think we need to try to sort of minimize it and solve it to the extent we can. And to me, one of the ways to do that is to have a more open market and set of choices, right? I think part of the things that makes it harder is if you've only got one search engine that everybody uses, if you've only got one social media company that everybody uses, right? That company's choices of values, right, are going to be the ones that are the default. If you've got a bunch of choices, different people can have different options.
Okay, thank you for that very detailed answer. There's also a question by Wolfgang Kerber. I wonder if you can see that in the chat. Mark?
I think he's up. Maybe it was just to ask directly.
Yeah.
Yeah, sure. Go ahead.
Thank you very much for your clear presentation. And also, I think not only I am interested what you think about the Commission's proposal of the Digital Markets Act, because on one hand, this looks very much as a typical European regulatory approach. On the other hand, there are also some interesting obligations for unbundling and for less login and a bit more interoperability, perhaps not enough, for perhaps also helping to restart competition. So how do you see this proposal?
Yeah, so the short and perhaps unfair answer is, right, I don't know enough about it. I know I have been paying some attention to it, but it is an extraordinarily complex proposal. I do think you're right that there are efforts here maybe to go to Cinema's first question, right, at sort of maybe regulatory minimalism within the European framework, right? To say not just here is what everyone must do, but sort of here are ways to offer options. The whole problem of regulation of artificial intelligence, I think, is a really important and fascinating one that we're just now beginning to deal with. I think we're going to end up seeing some of those same contradictions. I mean, we already see some of them in the in thinking about sort of, well, I want transparency, but I also want privacy, for instance, right? When it comes to sort of how my data is processed, I think we'll see more of those. So I don't have a great answer for sort of, do I, up or down? How do I feel about the DMA? I think it's complicated.
Right. Any more questions? No? Right.
Well, thank you for staying late, and in my case early, in your case late on a Friday.
Thank you very much, everybody, and thank you very much, Professor Lemley. Yes, I think everybody's questions have been answered. Oh, Panos has a question. Do you still have time? We still have about 6 minutes, if you would mind taking the question. Go ahead, Panos. Would you like to just ask it directly? That might be simpler.
Yes, so I can read it as well. So I was trying to make a comparison between, let me switch on my camera. I don't know what you can see. Hopefully what you see is decent. So thank you very much for a very stimulating keynote speech, Professor Lemley. So what I was wondering, I was trying to think how financial innovation works versus innovation in the area of platforms. So I have the impression that when it comes to financial innovation, things seem to be working quite well in terms of, let's say, incremental, mostly incremental, I think, innovations. But there I have the impression that maybe the patent protection is not so much, maybe it's not enforced that much. My impression is that financial patent holders, they essentially seek whatever benefits from innovation via first mover advantage and reputation in the market, right? So you seem to suggest actually that more competition may alter, let's say, how things work in platform regulation. I was wondering, however, whether patent law may be a barrier in this regard by unduly protecting big tech, right? So I was wondering whether actually there seems to be a problem, and since you are a patent law expert, patent law authority, I was wondering whether you can say a few things about that, because I have the impression that this may be a quite high entry barrier. Thank
Sure.
you.
Yeah, interesting, great question. So I think you're right about the financial innovation, right? And that one of the things we see is not that there aren't patents, but that you don't see companies sort of using those patents to get effective control. The value really is in some combination of trade secrecy. How does my algorithm work, right? Or first mover advantage. I think that's actually generally true in the information technology space. And I think one of the issues is that the technology moves so fast and the patent system moves so slowly that whenever, if you spend 3 years getting a patent in the patent office and then you spend some more years in litigation, you're almost always fighting over old technology. We had a sort of giant trial between Apple and Samsung over smartphones, but they were always over 3 generations of smartphones earlier than the phone that was actually on the market. And so I think the result of, in part for that reason, it is also the case that the big tech companies and the startups aren't relying really on patent protection and the idea that they'll get to sort of exclude competitors from this market. I think they're relying on trade secrets and first mover advantages and network effects. Again, not that we don't see patents, we see lots of patents in this case, but they're not being asserted by the big tech companies against small players. I think the Google, I'm not sure Google has ever filed a patent suit. Apple might have filed 1 patent suit in its history, and in fact they turn out to be defendants in these sort of patent troll cases on a regular basis. So I'm not. I think I can see the worry, but I think it's less of a problem here than it might be in other industries, precisely because the patent system lags behind the sort of speed of innovation.
Great. So I think that brings us to the end of the time allocated. Thank you very much once again, Professor Lemley, for being here and for your very stimulating keynote address. We all enjoyed it very much.
Thank you.
Thank you to our audience. And I wish you all a great rest of the day. Bye-bye.